name is Craig Bronsnick, and I'm president of the Rutgers Federalist Society. The executive board of the Federalist Society would like to thank you all for coming today. We're proud to announce that today's debate will feature Mr. Ilya Shapira and Professor Frank Askin, and on the topic, Are Corporations Really People? Citizens United and the Future of Political Speech. Mr. Shapiro is a scholar at the Cato Institute. He is senior fellow in constitutional studies and editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was special assistant and advisor to the multinational force in Iraq on rule of law issues and practiced international, political, commercial, and antitrust litigation at Patton Boggs and Cleary Gottlieb. Mr. Shapiro has contributed to a variety of academic, popular, and professional publications, including the Harvard Journal of Law and Public Policy, LA Times, the Washington Times, Roll Call, National Review Online, and the Weekly Standard. He has provided legal commentary on just about every news channel you might watch, and worked as an adjunct professor at GW Law School. Before entering private practice, Mr. Shapiro clerked for Judge E. Grady Jolly of the U.S. Supreme Court of Appeals for the Fifth Circuit. He holds a bachelor's from Princeton, a master's from the London School of Economics, and a JD from the University of Chicago Law School. Mr. Shapiro will be debating in English today, although he can probably do so in about 5 other languages. Is that right? 5? About 5?
Does he do Yiddish?
Professor Askin is Rutgers Distinguished Professor of Law and founder and director of the Constitutional Litigation Clinic. Professor Askin has been a member of the National Board of American Civil Liberties Union since 1969 and has one of the ACLU's 4 general counsel and has been one of the ACLU's 4 general counsels since 1976. He is also a member of the board of directors of Project Vote. In 1986, he was a Democratic candidate for Congress in New Jersey's 11th district, covering parts of Essex and Morris counties. Professor Askin is one of the featured writers on the Star Ledger's New Jersey Voices.com. His memoir, Defending Rights, A Life in Law and Politics, was published in '97 by Humanities Press. He is listed in Woodward and White's Best Lawyers in America. Professor Askin has a bachelor's from the City College of New York and a JD from Rutgers. Mr. Shapiro will begin with a 20-minute presentation. Professor Askin will then give his 20-minute presentation, followed by a 5-minute response from Mr. Shapiro, and in turn a 5-minute rebuttal from Professor Askin. We will then have a question and answer session. At this time, at that time, please raise your hand, state your name and your class year, and please keep your questions brief and in the form of a question. And if for any reason you have to leave the room at any time, please keep the door, close the door quietly. And tomorrow, please come see Mr. Shapiro again for a debate. Did the Supreme Court properly decide Brown v. Entertainment Merchants Association here at this time? And now, please give a warm Rutgers welcome to our guest, Mr. Ilya Shapiro.
Thanks very much for having me. It's a great turnout. I recognize that that's due primarily to the food and secondarily to Professor Askin, so I'm just happy to provide whatever support to that I can. Few Supreme Court cases have provoked as much controversy as Citizens United. It was a 5-4 decision that emerged from a dispute over whether a nonprofit advocacy group could air a movie critical of Hillary Clinton while she was campaigning in the primaries for the Democratic presidential nomination. The court found in favor of this group, holding that the First Amendment prohibits limiting corporate and union funding of independent political speech, even and especially in the run-up to elections. Now, for decades, it's been understood that corporations are regarded as persons under the Constitution. Nonetheless, a corporation's right to participate in political dialogue has long been highly debated. Much of the criticism of Citizens United stems from the argument that the Constitution does not protect corporations, and certainly not in the speech context, because only natural persons, not legal ones, have constitutional rights. corporation isn't a real person and therefore should not be afforded First Amendment protections, let alone the ability to influence elections. As Justice Stevens said in his dissent in Citizens United, corporations have no consciences, no beliefs, no feelings, no thoughts, no desires. Corporations and their personhood often serve as a useful legal fiction, but they are not themselves members of we the people, by whom and for whom our Constitution was established. This is a common argument against corporate rights. But that sort of rhetorical appeal misses the point entirely. It demonstrates a fundamental misunderstanding of both the nature of corporations and the nature of the freedoms that are protected by the Constitution. Corporations, like any other associations of people, are entitled to constitutional rights in order to protect the rights of the individuals that make them up. The supposedly hot question of whether a corporation should really be considered a person is thus constitutionally irrelevant. It doesn't matter that corporations aren't really people. Now, it's also a misconception that the concept of corporate personhood has played a central role in shaping corporate speech rights. No court has ever said that corporations are real people in this or any other context. Going back to the 1819 landmark case of Dartmouth College versus Woodward, which established the principle that corporations are protected from alterations by the states for public reasons. Chief Justice Marshall emphasized that, quote, a corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. The court therefore acknowledged that a corporation isn't a real person, but nevertheless ruled that the charter given to it by the state was a contract the state was obligated to uphold. Now recall, this is even under the charter theory of corporations that existed during the early days of the Republic. Now, of course, we have general incorporation law, which are kind of akin to joint stock associations under common law, rather than a monopoly given, a charter given by the government. Chief Justice Marshall went on to explain that corporations are formed by individuals, and those individuals have constitutional rights. Corporations receive constitutional protection, as Dartmouth College did, he said, in order to protect the constitutional rights of the individuals behind the artificial entity. Now, skipping forward to the end of that century, in 1886, the Supreme Court established what would later become known as corporate personhood in the case of Santa Clara County versus Southern Pacific Railroad. One of the arguments that the lawyers briefed there was that corporations are persons within the meaning of the 14th Amendment. So there's an argument about the state that was arguably infringing on the corporation's rights. The parties were never given a chance to debate the issue, however, because Chief Justice Morrison White disposed of it before oral argument even began. He announced in open court, the court does not wish to hear argument on the question whether the provision in the 14th Amendment, which forbids a state to deny any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of the opinion that it does. It wasn't even a controversial question for the court. Now, critics of Santa Clara insisted that the decision gave corporations constitutional rights equivalent to the rights of natural citizens. Nevertheless, the critics' predictions never came to fruition. Instead, the cases that succeeded Santa Clara that sometimes limited corporate rights in ways that would not be possible in the context of individuals. There was a case in 1911, Wilson versus United States, where the court held that unlike individuals, corporations don't enjoy Fifth Amendment rights against self-incrimination. Other Lochner-era decisions regularly upheld state laws limiting corporations' contractual rights, even as the court was protecting the contractual rights of individuals. Yet the same criticism that followed Santa Clara, that corporate rights are now equivalent to the rights of natural individuals, resounded after Citizens United. And so when the court took up the case of FCC versus AT&T last year, it was thought to be a return to the debate over corporate personhood. But in that case, FCC versus AT&T, the first corporate rights case after Citizens United, the court clarified that the rights of corporations are, again, not equivalent to the rights of living, breathing human beings. It found in that case that the term personal privacy clearly applied to natural persons, but does not apply to artificial persons, relying on the ordinary meaning of the term personal, which ordinarily refers to individuals but not artificial persons. And the court therefore concluded that the phrase personal privacy conveys more than just of a person. It suggests a type of privacy evocative of human concerns. not the sort usually associated with an entity like AT&T. And you might remember those of you who read about the case or read the opinion, Chief Justice Roberts concluded for a unanimous court, we hope that AT&T doesn't take it personally. The court therefore made clear that the rights of artificial persons, notwithstanding the alarmist reaction to Citizens United, are not on par with the rights of natural or real persons. And if FCC versus AT&T is any indication of what's to come from the Supreme Court on future corporate rights cases, then we can expect decisions that don't so much open the floodgates for special interests, as President Obama intoned at his State of the Union last year, but a pattern of case-by-case adjudication that treats corporations differently from individuals, no more or less than in the period following Dartmouth College or Santa Clara. As FCC versus AT&T reinforced, corporations are artificial persons under the law that have never, and these types of entities have never enjoyed the same types of rights as the natural persons. But that doesn't mean that a corporation doesn't have any speech rights, or didn't have any until Citizens United. As Professor Adam Winkler of UCLA, no right-wing zealot at all, he said, although not equivalent to the speech rights of individuals, corporate speech rights do exist. For example, the Central Hudson case. The court held that corporations have certain types of rights relating to commercial speech. In the First National Bank of Boston versus Bellotti case, the court treated a corporation's political speech much the same as the speech of individuals. So this concept of corporate personhood is at most tangential to the court's jurisprudence about speech. Instead, the speaker's identity is irrelevant for First Amendment analysis, which instead turns on the scope of protection for the speech at issue. So commercial speech is treated differently from political speech, which is treated different from other types of speech. For instance, corporations, and speech is different than other types of protections under the Constitution, whether in corporate or other circumstances. For example, corporations are entitled to Fourth Amendment protections against unreasonable searches and seizures, even as they're not entitled to Fifth Amendment privilege against self-incrimination. Nor are corporations covered by the 14th Amendment Privileges or Immunities Clause, or Article 4's Comity Clause. In each of these contexts, the court looks not to the ramifications of corporate personhood, but at the nature of the right at issue, and whether it makes constitutional sense to extend that right beyond natural persons. And so we're left with the idea that corporations are, again, artificial persons entitled to certain constitutional rights, which sometimes approach but never exceed those of individual natural persons. All right, but where do these rights, apart from Chief Justice Waite's statement in Santa Clara, where do these rights come from in the context of corporations? Well, the anti-corporate right crowd is correct in that a corporation is not a real person. That's a rather obvious conclusion on which all of us of any ideology or jurisprudential tradition can agree. Edward, the first Baron of Thurlow, I love this English history, put it best. Did you ever expect a corporation to have a conscience when it has no soul to be damned and no body to be kicked? Kind of an older evocation of what Justice Stevens said in Citizens United. And so the Constitution doesn't apply to corporations in the same way that it applies to all of us sitting here today. Indeed, many constitutionally protected rights simply make no sense in the corporate context. For example, the protection of sexual privacy and prohibition of slavery are meaningless in the corporate context. However, even though a corporation isn't a living, breathing, blood-pumping human being, the individuals who make up these corporations, the officers, the directors, the employees, the shareholders, are. And it would be a mistake to deny constitutional rights to all of these individuals on the grounds that they have come together or to form a corporation which itself is not a real person. The rhetorical tactic of conflating a right with the means used to exercise it, a tactic that misses the larger point. The people who own and operate the corporation are themselves natural rights-bearing individuals who don't shed, these individuals who come together in whatever way, don't shed their constitutional rights at the office building door. They have their individual rights acting individually, then when they stand together as a group, they shouldn't be stripped of them. The contention that the Constitution doesn't protect rights in that manner ignores the absence of a distinction between individuals and groups of individuals. Indeed, we have First Amendment protections for the freedom of association. People are free to organize and associate in a whole host of manners. And the decision to use the corporate form, as opposed to partnership, a union, an informal grouping, friends coming together to pool their assets, does not strip them of constitutional rights, such as the freedom of speech. And common sense tells us that corporations have to have some constitutional rights, or there'd be little incentive to form them in the first place. Because, for example, if corporations didn't have Fourth Amendment rights, then the police could storm corporate offices and seize computers and files at will. If corporations didn't have Fifth Amendment rights, not against self-incrimination, but the takings clause, well then Mayor Bloomberg could decide to exercise eminent domain over Rockefeller Center if he wanted to have his office there. If forming a corporation means losing all of these and other protections under the Constitution, then the only form of business would be sole proprietorships and the proverbial mom and pop shop. Similar to these Fourth and Fifth Amendment examples, the Constitution has to protect First Amendment rights of people who are associating through the corporate form. But that corporate form itself doesn't create new constitutional rights. It's merely a vehicle for people to exercise their own rights. As Eugene Bullock, also of UCLA, says, the court has long understood that to speak effectively in a vast nation, you need to be able to pool your resources with others. The court has recognized many times within the realm of the right to expressive association that corporate speech is just one form of that association. As Chief Justice Roberts said during oral arguments in Citizens United, the First Amendment protects more than just the individual on a soapbox or the lonely pamphleteer. And so we have this useful legal fiction, the corporation, that are indisputably non-human entities, but like natural persons have assorted rights, as well as privileges, liabilities, responsibilities, and other legal ties under statutory, constitutional, and common law. But the reason corporations have these rights, again, aren't because they're legal persons, which is just a useful construct for dealing in a legal setting, but instead because it's, again, one of the myriad ways in which individuals, rights-bearing individuals, come together and associate. And so what we think of as corporate actions, speech or otherwise, is just individuals using the corporate form to act, including, or for example, to communicate a message. And so the specific rights at issue are the rights of the individuals who own and operate the corporation. The legal conceit that companies are natural persons is vital to capitalism. That's why we have this legal fiction. No one's saying that the corporation is a real human being, but simply that it has the power to form certain legal relationships, to behave as a legal person for certain purposes. Personhood facilitates commerce and allows corporations to more effectively participate in transactions. It's also useful because a corporation, along with being an aggregation of rights-bearing individuals, is a nexus of contracts. Government regulation of corporations obviously impacts the people for whose relationships the corporation serves as a nexus of those contracts. And in this context, it's essential to protect the parties to these various contracts that the corporation can enter into. Whether or not one accepts the notion of the corporation as a mere legal fiction, however, the result's the same. They're entitled to certain rights. If you accept the legal fiction of the corporation as a separate, rights-bearing legal person, then taking its property violates its rights. But if you reject that fiction as a means of arguing that the corporation should lack rights, then taking its property violates its owner's rights, the individual's, more directly. Either way, the result is the same. The Constitution, the takings clause in this example of the government taking someone's property, applies to protect the rights of the individuals, the real persons, affected. And either way, this legal fiction should be utilized because it makes the analysis easier, even without altering the results. A world without corporate speech rights also necessarily implies a world where government is empowered to shut down speech because it does not like criticism of its policies, which is a profoundly undemocratic development. Remember, it's easier to speak when you can pool your resources. And so if corporations or individuals are prevented just from speaking through the corporate form, again, whether that be a for-profit corporation, a union, a non-profit advocacy group, or whatever, then that makes it easier for the government to shut down speech, a fundamentally undemocratic event. And remember, during the first oral argument in Citizens United, part of the indication that the government was going to lose here, and indeed what I think triggered this court scheduling further briefing and re-argument, was when the Solicitor General, the Assistant Solicitor General, when asked whether the government could ban books put out by corporations that just said, vote for or against Hillary or what have you. And the Solicitor General logically said yes. That was an indication that something was wrong with this theory. If only individuals acting alone can speak, unable to pool their resources, that speech will be less effective and the government less constrained. Before I conclude, I want to mention another argument that's often advanced against corporate rights, and that's that the government is the sole source of these rights. The law, after all, is a creature of government, and if it didn't recognize corporations, they wouldn't exist, and so the government has the power to limit or define those corporate rights. Under this theory, the rights-bearing individuals are not entitled to constitutional protections when they use the corporate form, because corporations are state-created entities. Again, even going beyond an understanding that they're no longer the same type of state-created entities that they were 200 years ago when they were state charters given to corporations to exercise a monopoly in a given industry. And since corporations now exist only due to government-issued licenses, the government can attach conditions on those licenses to define those entities' rights. This claim is slightly different than the corporations aren't real people argument, but it shares many of the same weaknesses. First, the Supreme Court has long recognized that the government doesn't have a free hand to impose conditions on grants of benefits. Although the government has significant power to define the rules of property, contract, and corporate law, and some additional power to attach strings to grants of benefits, that power doesn't include the ability to impose unlimited conditions on the enjoyment of those particular benefits. And this is so particularly when the would-be condition is a waiver of a constitutional right. So for example, a state can say that you have to be 16 years old to get a driver's license and pass a road test, but it can't say that to get that license you have to refrain from criticizing the DMV. Similarly, a state can subject corporations to all sorts of environmental and accounting regulations, but it can't prohibit them from speaking. And that makes sense. If the government had the ability to impose conditions on any state-created institution, it would have virtually unlimited power over our lives. What if it conditioned the grant of a marriage license on the agreement on penalty of law to have only one child, for example? Or, in light of, as Rick Perry says, the Ponzi scheme that our welfare entitlements have become, you have to have at least 2 children to get a marriage license. Or, returning to the previous example, what if to preserve Mayor Bloomberg's option on new office space, the government conditioned the grant of a corporate license on that company's waiver of its Fifth Amendment rights under the Takings Clause? And if you accept the notion that the government has plenary authority over state-created entities, it's difficult to find the limiting principle of the object of that authority. As George Mason law professor Ilya, my nominal doppelganger, as it were, has said, nearly everyone and everything can be categorized as a state-created entity. If the notion of a state-created entity is defined broadly to refer to the particular bundle of legal rights currently attached to the corporate form, then virtually all other organizations are state-created entities as well. Universities, schools, churches, partnerships, etc. Even individual citizens might be considered a state-created entity because citizenship is a state-created designation or status which grants its holders certain types of rights that are constitutionally or statutorily defined. On the other hand, if state-created entity is defined narrowly, then it would not include most corporations because even if the corporate status was abolished by statute, most corporations would still exist and continue to operate to engage in their business activities in some other form. So even if the government abolished the corporate form, most companies would continue as less efficient, in less efficient legal statuses, LLC, partnerships, joint ventures, what have you. There would still be a demand for the products produced by these X corporations because economic forces aren't dependent on state sanction. And so corporate actions are really the responses of various people acting under that corporation's authority to meet the demand of other people in the marketplace. And so we circle back to the idea that corporate rights are bound up in the rights of individuals. And so, in conclusion, the charge that corporations aren't people and thus should not be afforded constitutional rights is legally baseless and logically irrelevant. Justice Stevens was right that corporations aren't people and, quote, have no consciences, no beliefs, no feelings, no thoughts, no desires. But it's a convenient legal fiction to grant corporations a certain personhood. And more importantly, corporations consist of human individuals who enjoy a panoply of constitutional protections. When rights-bearing individuals associate to better engage in a whole host of constitutionally protected activity, their rights remain fully intact. These individuals do not lose their right to speak or act simply because they choose to exercise their rights by pooling their resources in a corporate or other form. While corporations are not entitled to the same rights as natural persons, they are entitled to some rights. If you pierce their corporate veils, they will not bleed. But if you ban their political speech, they will suffer a constitutional offense. Thanks.
Good afternoon. First, a disclaimer. Despite my long association with the ACLU, which Craig noted in his introduction, I do not speak for the ACLU on issues of campaign finance. In fact, I'm a part of a large dissenting minority in the ACLU on issues of campaign finance. Also, before I get into my remarks, I'd like to show of hands. How many of you think Saudi Arabian oil companies and the Chinese government should be allowed to spend money to influence the outcome of U.S. elections? How many think not?
Repeat the question, please.
Who thinks the Saudi Arabian oil companies and or the Chinese government should be allowed to spend money to influence the outcome of U.S. elections? How many? I see 4 or 5 hands. 6. How many think not? Good majority. Well, if the Supreme Court majority in Citizens United is correct, that the First Amendment prohibition on abridgment of speech is a source-based rule that is based on speakers, then it's hard to think of a logical justification for restricting such expenditures. If it's just protecting speech, then anybody can speak, if that's what the First Amendment is really about. It was Teddy Roosevelt who in his 1905 State of the Union address said as follows: "The fortunes amassed through corporate organizations are now so large and thus vest such power in those that wield them as to make it a matter of necessity to give the sovereign, that is to the government which represents the people as a whole, some effective power of supervision over their corporate use." And that was the law of the land, and that became the Tillman Act in 1907. And that was the law of the land for 103 years. Corporations were not allowed to spend money to elect candidates for federal office. Although under the Federal Election Campaign Act in 1974, they could set up political action committees, which means the corporation could pay the costs and administration of political action committees. But the only money the committees could spend for political influence was the personal contributions of their class, the restricted class, that is shareholders and elect administrative and senior officials of the corporation. They could contribute a limited amount to the political action committee without, that money could be spent by the PAC for political purposes. All right, then a year and a half ago, a 5-4 majority undid 103 years of American law, holding that ExxonMobil and Halliburton are just like you and me and are part of we the people who established our constitutional regime, and thus could spend unlimited amounts from their corporate treasuries to help elect candidates, so long as they were not coordinated with the candidates themselves. That is, they were independent expenditures. Although the definition of independent, of uncoordinated or coordinated, is really quite vague. In doing so, as Mr. Shapiro noted, the court decided an issue not even before it. Citizens United was a simple case which could have been easily disposed of on very narrow grounds under existing law. But the Supreme Court set it down for re-argument and told the parties to brief the issue of corporate free speech. The result was not only bad law, but disastrous policy. We now know how much money corporate America, under the leadership of the Koch brothers, poured into the 2010 midterm elections to bring far-right Republicans to Capitol Hill and are now gearing to turn over the White House in 2012. As a preview of 2012, the Wisconsin Senate recall election in summer became the most expensive state legislative elections in history. And thanks to the Republican filibuster of the Disclose Act, most of this money comes from anonymous sources in the name of innocent-sounding groups like American Crossroads and American Action Network and Mothers for Apple Pie. The legal justification for this disastrous policy transformation is the language of the First Amendment. Congress shall make no laws, which the majority redefined as an identity or source-based rule favoring unlimited speech. The more information to educate the electorate, the better, even if it means the financially powerful can drown out their opponents. As a constitutional principle, as I suggested before, that should mean that even foreign-controlled corporations and foreign governments can try to buy American elections. And of course, we all recall the little to-do between President Obama and Justice Alito during Obama's State of the Union address, when he criticized Citizens Union for this on this ground, and Alito mouthed, "Not so." Well, it's hard to see on what principled basis the majority could limit their source-based rule. If the view is the more speech the better, then anything goes, and the identity of the speaker is irrelevant. On the other hand, the Supreme Court majority doesn't always think more speech is better. In the Arizona public financing case decided in June, they found more speech is not always a good thing. At least not when it means allowing publicly funded candidates to get additional grants when outspent by a privately funded candidate. At that point, the majority found that extra speech was an abridgment of the speech of the free spending candidate. So I guess the conservative majority can always tell us that consistency is just the hobgoblin of liberal minds. Whatever their theory, Justice Kagan properly called it in her dissent chutzpah.
I thought we agreed there would be no Yiddish in this.
That's for some minute. The Citizens United majority buttressed its views by identifying Halliburton, and ExxonMobil as, quote, associations of people, just like the NAACP or the NRA, which of course have the right to speak for their members. But that's unadulterated nonsense. As Justice Stevens wrote in his dissent, and Mr. Shapira quoted, corporations have no conscience, they have no morals, they have no ideas other than to make money. As Chief Justice John Marshall wrote nearly 200 years ago, and I don't think Mr. Shapiro quoted all of this quote, a corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Being the mere creature of law, it possesses only those properties which the charter of creation confers upon it, whereas incidental to its very existence. These are at best calculated to affect the object for which it was created. And corporations were certainly not created to influence elections. And indeed, the conservative icon, William Rehnquist, endorsed those words in the Bellotti case. Or as the legal philosopher Richard Dworkin wrote after Citizens United, and I quote, "It is essential to any government's legitimacy that it treats the opinions of all citizens as equal in the political process. No one must be denied an opportunity to present his political opinions as best he can to his fellow citizens. No one may be told by government that his opinions are not worthy of audience or consideration. But corporations are not citizens whose political equality can be respected or denied. They're artificial entities created not to form and express values, but to make and shelter money. No one is insulted or relegated to second-class status because corporations are not given the rights of real people." Corporations' political views are those of their managers who are using other people's money, customers, shareholders. And the Citizens United majority notion that shareholders can protect themselves by selling their stock is as fallacious as the notion that corporations are merely associations of people. First of all, most people don't even know what stock they own. It's managed by third parties. It's in IRAs and mutual funds, pension funds. They don't know what their money is invested in. Nor is the absence of disclosure legislation. Even if you knew where your money was invested, you don't know when it's being used for political purposes. The legal distinction between business corporations and nonprofit associations had been established 20 years ago in Austin versus Michigan Chamber of Commerce, which was overruled, specifically overruled in Citizens United. Austin distinguished MCFL, Massachusetts Citizens for Life, which had held that nonprofit membership corporations, which did not accept contributions from business corporations in their treasury, they were exempt from the restrictions on corporate expenditures since they were speaking for their members. And as Austin held, business corporations have no ideas of their own. They simply parrot the ideas of their managers, who could speak on their own as individuals or through their political action committees that collect money only from people who wish it to be spent that way. The preamble of our Constitution states that we, the people of the United States, do ordain and establish this Constitution. The Declaration of Independence declares that we, again obviously referring to the people, hold these truths to be self-evident. That all men are created equal and are endowed by their Creator with certain inalienable rights and to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. As Justice Ginsburg observed in the Citizens United argument, nowhere do these documents suggest that corporations are part of we the people or have any inalienable rights. That indeed corporations are artificial entities created by the states and given such rights as the states believe they need in order to carry out the economic purposes for which they were created. And if the state does not wish to provide such entities with the rights of free speech, there is nothing in the Constitution which requires them to do so. The Citizens United view of the First Amendment rests, I believe, on two very shaky legs. One, that the only ground for Congress to restrict speech is to prevent corruption. And secondly, a very narrow view of what constitutes corruption. The majority categorically rejects the notion that equality or fairness in elections are legitimate public interest. The minority apparently believes it would be appropriate in a debate or in a courtroom to allow for one side to pay for 50 minutes and leave only 10 minutes for the other side. Then comes the crabbed definition of corruption. In the majority's view, so long as corporations are spending shareholders' dollars without coordination with a candidate, that cannot corrupt the system. As if I spend $1 million to elect a senator, that senator will have no sense of obligation to me. It was Barney Frank who once said, elected officials must be the most ungrateful people in the world. They're supposed to spit in the eye of their benefactors. The only real case precedent the majority could find in Citizens United was Bellotti versus the Bank of Boston, which narrowly upheld the right of a corporation to spend its money to defeat a referendum. But Justice Stevens said in his dissent in Citizens United, a referendum cannot owe a political debt, seek to curry favor with a corporation, or fear the corporation's retaliation. Finally, the majority hides behind the media exemption in the Federal Election Campaign Act. Since most media entities are owned by media corporations, we have to extend, according to the majority, the exemption to all corporations. I consider that sophistry. In other words, they would amend the First Amendment to read, Congress shall make no laws abridging the freedom of speech of corporations. Talk about give them an inch, and they'll take a mile. They would turn the press clause of the First Amendment into a Bill of Rights for corporate America. As I said, this is sheer sophistry. The fact is there are good and proper reasons for protecting press freedom, which has nothing to do with corporate rights. Just because Rupert Murdoch has the right to use the Post's corporate resources to advocate his political views does not require that Halliburton be given the same right. It's really the tail wagging the dog. Either you have to let the media tail drag the corporate dog under the First Amendment, or throw out the media baby with the corporate bathwater. I think that's a false choice. And the fact is that media entities do have special protection under the press clause of the First Amendment. Congress shall make no law abridging the freedom of the press. GE may own NBC, and NBC has speech protection, but that protection does not extend to the parent corporation itself. Nor does the press exemption extend to the New York Times' lumber interests. The truth is that media corporations, no matter what their owners' personal views, still must report news in a somewhat objective way, or else they'll be preaching only to the choir and will not be able to compete in the marketplace. How long do you think a daily newspaper published by the Republican National Committee could survive in the marketplace? Remember who was Rudy Giuliani's major media backer? It was Rupert Murdoch. And do you remember who took the lead in destroying Giuliani's Senate campaign in New York by exposing his extramarital affair with Judith Nathanson? The same New York Post. That's because in order to be competitive in the cutthroat media market, media has to at least make some pretense as being an objective purveyor of news. Even the Wall Street Journal has to acknowledge their publisher's hacking scandal in Great Britain. For me, the bottom line is that the U.S. Constitution was written by and for we the people of the United States, and economic corporations are not part of we the people, who are the only ones who can vote and govern our own public affairs. Thank you.
Well, I'm a little bit at a loss to respond because I was playing phone tag all morning with the Koch brothers and just was not able to get their marching orders. So we'll have to see what I can come up with on my own. So first of all, Professor Askin repeats the canard, the series of errors that President Obama made in his State of the Union last year. In the course of 2 sentences or a paragraph of his speech, he managed to, this constitutional law professor, as Professor Askin did, made 3 fundamental errors. First, the critique is that we're going to have foreign interests starting to fund our elections. The Saudi oil companies, the Chinese government that Professor Askin detailed. I voted, by the way, against their having a say in our political discourse. Citizens United does not change one word, one comma, the existing prohibitions on either foreign individuals or corporate interests from speaking, voting, influencing our elections, or what have you. Next, that corporations all of a sudden are going to be donating to candidates and campaigns and all sorts of things. That doesn't change. We have not affected 100. We have not reversed the Tillman Act, which prohibited corporations from donating to candidates and campaigns. 50 years later, same prohibition being applied to unions under Taft-Hartley. That does not change. Now, if there's a problem with corporation coordinating, wink, wink, then the FEC should be enforcing its coordination rules. But that's not a problem of you still can't donate. Corporations still can't donate directly to campaigns. And finally, the open the floodgates thing. All of a sudden, we're going to see all of this corporate money washing away anything else that we had before. The statistical evidence, the empirical evidence simply, it might be too short a time. There's only been a couple of years since Citizens United, but Americans spend more money on chewing gum in any given year, election year, presidential election year, or otherwise, than they do on elections. Fundamentally, for-profit corporations, and remember, we're not just talking about for-profit corporations. Citizens United was the group itself. The case at hand was an non-profit advocacy group. And the case applied to unions, nonprofits, all sorts of different associations, corporate and otherwise. But for-profit corporations, if that's the real concern, they will only indeed spend if they are helping their bottom line. You're not going to have GE or Microsoft or whoever running ads about some vote against this candidate because he's pro-life or pro-choice or something like this. Michael Jordan was once criticized for not being vocal about civil rights or otherwise politically engaged. And he said, well, Republicans buy sneakers too. And this is the attitude of for-profit corporations. They're not going to want to piss off half of their clientele. Indeed, the money that they've spent now or before Citizens United on lobbyists will always will always be so much more than what they spend on political speech, on issue ads and whatever. It's much more effective to have targeted lobbying, and of course lobbying is protected as the right to petition your government. I think before Citizens United the ratio was about 10 to 1. Now it might be 5 to 1 or 7 to 1 or what have you, but still lobbying is much more effective and they'll continue to spend money on that. A couple of other little points. I urge you all to read Justice Kennedy's majority opinion about why this decision could not have been decided on narrower grounds, on exemptions and so forth. He goes through methodically. It's a very long opinion. Going through that. The Arizona Free Enterprise case, the public financing of elections, it's the same ultimately as the Millionaires Amendment case, Davis versus FEC from a few years back. It wasn't the issue that more speech is corrupting or violates the First Amendment. It's that the taxpayers are paying for that more speech when the individual candidate speaks. So essentially, the more I speak, the more money from the taxpayers, the more state-supported speech my opponent gets, or opponents, or individual groups who I have no control over. If they speak to, quote, support me, my opponents will get more money. So that's problematic. Indeed, chutzpah is not what Justice Kagan was talking about, but it's what the government was arguing. The government, under established law, indeed, as Professor Askin said, the only justification for limiting political speech is corruption or appearance of corruption. And the government said, this is what we're doing. We're not about leveling the playing field of political spending. And yet, Chief Justice Roberts, the morning of the argument, went on, he said this during the argument, went on the website of Arizona Clean Elections, the agency that enforces the public financing, and found the first paragraph, we're here to level the playing field of political speech. That, I think, is chutzpah. And finally, on the topic of media corporations, if we accept the argument that corporations, for whatever reason, shouldn't enjoy constitutional rights, then it follows that the government would be free to censor all corporations, including those that own the Wall Street Journal, New York Times, MSNBC, National Review, etc. And that's because all of those are corporate. There's something intuitively wrong with the state of affairs where, whether it's the ACLU, the NRA, the Catholic Church, those are all corporations. There's no media exemption for them. And press, the protection of the press is an activity, not a speaker. Adam Liptak he's the Supreme Court correspondent for the New York Times, had a great article in February of this year that this is a problem for the liberal position. He says, there's little evidence that the drafters of the First Amendment meant to single out a set of businesses for special protection, nor is there much support for the idea that the Supreme Court's decisions, which have rejected the arguments that the institutional press have rights beyond those of other speakers. Indeed, the First Amendment speaks of freedom of the press as a certain type of protected activity, not a class of protected persons. Goes on Liptak to say, freedom of the press is not a constitutional right for a particular group of people or organizations. Rather, it's a right to engage in a certain class of activities, such as publishing newspapers and pamphlets, whether the person doing so is a professional member of the media or not. And of course, now, with bloggers and so forth, how do you judge what was a member of the press if it's a certain class of people? Do you have to have a certain number of friends on Facebook or followers on Twitter to be officially protected by that? I mean, what Liptak wrote parallels what Scalia said in his Citizens United concurrence. There's no reason why General Electric, which owns NBC, should enjoy greater First Amendment protections than its competitors Siemens or Citigroup, and no principled reason why the press activity of the hypothetical Citizens United Daily Journal would be protected while that of Citizens United, the actual advocacy group, or a fictional Citizens U, the widget manufacturer, would not. Oh, and if the problem is shareholder protections, then the solution is to fix corporate law and change, when people should be notified about what stocks they own and how they can sell them and how they can pressure their directors and officers and so forth. Thanks.
Since food for thought is obviously less compelling than food for the body, and our audience is greatly dwindled, I'm only going to have a few comments. First of all, anybody who thinks that corporate America is not prepared to spend billions of dollars to defeat congressmen and senators who favor regulation of corporate America, then I got a bridge to sell you. Which congressman will even stand up in the face of threats that they will be a target of corporate America when it comes time for re-election? Who will stand up for regulation of corporate America? I want to say a couple words about free speech and constitutional rights in general. The fact that corporations have some constitutional rights does not mean they have all constitutional rights. What they have are the rights necessary to protect their basic reason for being. which is to hold and own and amass property. So of course their property rights are protected under the Fifth Amendment, the taking clause, what have you. Certainly they have some constitutional rights which deal with their basic essence of their being, and they have to be protected. And they're their shareholders' rights, so their property is certainly protected. That does not extend to free speech. That's not why corporations are protected, to try to influence the political process. And finally, I just might make one note. The Supreme Court in 1886, there is no opinion of the court which says corporations have constitutional rights. It's the reporter's note of what the Chief Justice said in preamble to the oral argument. There's nothing in the opinion about corporate rights. But that off-the-cuff comment by the Chief Justice was later taken up by the Supreme Court in a variety of mostly corporate property rights during the Lochner era to explain that corporations have constitutional rights. Had nothing to do, though, there's nothing in the opinion of Santa Clara about corporations having any rights, and certainly nothing about free speech rights. Thank you.
Questions? Jason?
A question for Professor Askin. Jason Marca, 3L. When you're talking about the distinction between media companies and other companies, doesn't that become? I guess I'm saying what would be the logical distinction? Does owning one newspaper make it a media company? 3, a channel, half a channel? Like when you're talking about that, where does that distinction?
That they're in there to publicize ideas, the press.
Right, but
I mean, the First Amendment protects freedom of the press. What was the press? It was the printing press. So today, the printing press is a lot of, it's expanded. It's more than a simple printing press. It includes the internet. It excludes the, basically, there are distinctions. The court will sometimes have to be made. When is a blogger part of the press, when not? There's some narrow questions. The courts work out these kind of distinctions all the time. But the press is clearly part of the institution which educates the American people through exchange of ideas in basically the printed word, or now not just the printed word, but the electronic word. So I don't think there's a big deal there. I mean, television is the press, radio is the press, newspapers and magazines are the press. At some point, we'll have to distinguish which bloggers are part of the press and which are not.
But
As simple as that.
Let's say if GE were to open, not as a subsidiary company, but they just decided to do a for-profit media wing, and they just started putting out newspapers, but then all of GE, like, that's where I was going with that. If you're drawing the distinction based on
GE owns NBC. Whenever NBC is a subsidiary corporation of GE, NBC is protected by the press amendment.
Right, but if they don't do it through a subsidiary, they just, decide.
And if NBC is a subsidiary, doesn't get pressure from its corporate bigwigs at GE, then
They can do
I
it.
have a bridge to sell you.
They can do what they want. They can pressure anybody they want. Rupert Murdoch can pressure the Wall Street Journal what he wants to put in their columns. But as long as it's the Wall Street Journal, they're protected by the press. Rupert Murdoch's other international business dealings, whatever they are, real estate or what have you, they're not part of his press empire.
So why does GE or Rupert Murdoch get media protections for his media entities, but Siemens' blog or Citibank's blog does not? Or their corporate newsletter or what have you?
At some point, if they're really they're really the press, we have to make those distinctions at some point. Who's the press and who isn't?
Based
And
on
the Supreme Court makes these distinctions all the time.
based on a Stephen Breyer multi-factor balancing test, good for this.
I'm not going to get, that's, get into that thing, but the Supreme Court, the courts make these distinctions all the time. Who is the press and who is not the press? But clearly, General Electric's manufacturing television sets or washing machines, they're not part of the press.
Well, actually, my question was answered in the exchange back and forth. So I guess I should just, put a disclaimer that, correction, GE doesn't own NBC, Comcast does. So everybody keeps saying that.
Okay.
GE, I'm sorry, it's annoying.
I'm a simple constitutional lawyer. I don't understand these complex business structures.
Go ahead.
My name's Catherine O'Hearn. I'm a second year. My question is about unions and the distinction between a union and a corporation? And specifically, it's my understanding that teachers in certain counties, when you become a teacher, you must pay union dues if you want the job as a teacher. So automatically you're a member of the union, whether you want to be or not. If you want the job, kind of like if you want to be hired by a company, you have to do certain things. So my question to both of you would be, could you delineate the difference between, a situation where the corporation would then give money to a campaign and a union would also give money to a campaign, and how they might be alike and how they might be different?
Yeah, it's a good question. First of all, where union membership is a requirement, then those members, those unwilling members, they have to pay a dues for the collective bargaining work of the union. They have a right to a refund of any money the union uses for political purposes. That they get a rebate on. Corporations, shareholders don't get a rebate if they don't like the political work of the corporation. They get no rebate. So there's a distinction there. But for union members, that's protected. In many states, there is no such thing as unwilling union members. They're right-to-work states. You can't even make union members pay anything into the union. But in some states, like New Jersey, you can have a contract which says everybody has to be in the union. They have to pay dues to protect their collective bargaining rights, but they can get a rebate for political dues, which they don't want, political expenditures they don't want to pay.
Yeah, this is the intersection of the National Labor Relations Act with First Amendment and campaign law. And indeed, you can't even, in some states, you don't have to become a member of the union, but you do have to pay the union dues that go towards collective bargaining as opposed to other activities, because otherwise the courts have held that provision would be okay, because there's a state interest in preventing free riding on the collective bargaining of the union to secure them their work conditions and salaries and so forth. But again, you can't be forced to pay for political contributions. There's a Supreme Court case this term, it will be argued next month, about a situation like this in California, where if the union wants to engage in political speech and they levy special assessments in the middle of the year, they have to issue these what are called Hudson notices. And in this case, the union, or if they want to engage in, anytime they engage in political activity, they have to issue these Hudson notices. And the practice in California has been to issue these at the end of the year, so you can ask for a refund later or litigate it later or something, but your money's already being spent. And the workers there who are not members of the union, this isn't even an issue of the members of the union complaining about that their money is going towards causes they don't like or something like that, but it's not members of the union who have to pay in due to this anti-free riding provision. And they're not getting their Hudson notices until some later time, and they have to go through this process to get it back. Anyway, that's an issue for the court, that the Supreme Court is looking on appeal. There's other, all sorts of body of jurisprudence that has arisen about compelled speech in a union context, and it opens up a whole new can of worms about constitutional and policy issues with how the NLRA can or should be reformed.
I'm actually going to go ahead and ask a question myself. So the debate topic is, are corporations people? Now, what do you say about that Congress shall make no law prohibiting or abridging the freedom of speech, not directing, other than the or of the press, not directing toward any particular speaker? What say you on that?
I say that freedom of speech is blind as to the nature of the speaker, and restrictions on foreign companies, for example, are akin to the restrictions on voting. They're related not to problems with the speech. They're related to the organization of government, and people that are part of a polity have a say in that polity. People that aren't do not. And so again, for the reasons that I laid out, that I read Liptak about the media exception. Scalia has a similar thing. It's written, First Amendment's written in terms of speech, not speakers, not about any category of speaker, from individuals, partnerships, unassociated, unincorporated associations, incorporated, and so forth. And so that is part of the analysis. And Nick Rosencrantz, who's a professor at Georgetown, has a couple of really interesting articles about grammar in the Constitution, called The Objects of the Constitution, the Subjects. So you really like break it down. So in some part it says Congress shall make no law. In other parts it says, there's passive constructions and active. So what is the subject? Here the active component is speech rather than the speaker.
So you think corporations should have the right to vote then?
And of course not.
They're part of the
not
polity
natural
of the
people.
United States, you're saying?
No, I'm saying the individuals that make them up are part of the polity, and the individuals that make up the Saudi oil company are not. But the American individual, the U.S. citizens that work for the Saudi oil company or whatever should be allowed to vote, and they should be able to contribute, and they are.
Question. My name is Sabor Guy, third year law student, first year PhD student. I have a question in the topic of compelled speech. Now, maybe you can shed some light on this, but the First Amendment not just protects the ability to speak, but prevents compelled speech. So, in a sense, a corporation that's able to sort of, engage in First Amendment rights, those agents that make up the corporation, where do you draw the line between sort of having those agents be represented in the overall speech of the corporation when it may have conflicting views?
The business judgment rule, similar to how there can be strike suits against corporate officers and directors for misusing the assets of the corporation and its business activities. If the corporation is engaging in speech that is, by the appropriate legal standard, maybe under corporate law that legal standard might need to change. I don't know. If they're doing that in a way that doesn't help the bottom line, then shareholders can sue. And if they don't like some other aspect, then they can, if it doesn't rise to the level of misconduct or violating rational business judgment, then they can sell if they don't like it for some other reason.
It's entirely possible this is an failure of my understanding of corporate law, but if we're, sorry, this is for,
Shapira.
sorry, Mr. Shapira. What would stop if we're talking about keeping Saudi oil companies out of elections, what would stop a Saudi oil company from having a wholly owned American subsidiary and then us exerting pressure, which is the way we talked about with other things? What would stop that? Anything?
There are regulations of that. It's something like I forget what the thing is. It's an American subsidiary, can't be wholly owned. I forget what the regulations are, but those might need to be looked at again. That's more of a kind of a corporate regulatory type of question than a constitutional one. It really is minute. It says that the board of directors can't be more than 20% foreigners or something like this. So there are those rules in place, and again, I don't have the specifics off the top of my head, so it could well be that there are good arguments for tweaking those rules.
But do the rules apply to shareholders? Because the board of directors can't be more than 20%. That's all well and good, but if all the shares are, held by Saudis, then they just vote out a board that would disagree with them.
Well, shareholders, let's see. So even if it's a GM, let's say 80% of the shares are owned by Saudi individuals, foreign individuals or something. That's a very interesting question. I would think that if the way that the profit rules are, and now you're implicating tax code and how you domesticate the profits and where they're kept and things like this. It opens up again. This is a corporate regulatory issue, but if it's for the benefit of, because there's more stakeholders in a corporation than just shareholders. Like I said, there's directors and officers and employees and customers and whatever. So it's kind of a very complex analysis that you're starting to get into that you could make a good paper out of or even teach a class in.
The Disclosed Act, which Republicans filibustered in the Senate, had very specific provisions about when a corporation would be considered foreign and when it would be considered domestic, depending upon the number of shareholders, number of directors. There were very specific provisions, but that never got passed. And I'm not sure in the absence of that, I'm not sure what the existing law says about that.
Final question.
That wasn't the reason it was filibustered.
If a group of shareholders were to bring an action against management or the board, acknowledging that what they have done in setting up their political program has actually been to the benefit of the corporation. But the gravamen of their complaint is they disagree ideologically with what has been promoted. it is not a question of whether or not there's been less money coming in. It is that they disagree with the ideological bent of the corporate management. What is likely to occur under those circumstances?
That suit would be dismissed.
What?
That suit would be dismissed, and rightly so, because the corporate officer's only concern is and should be under the law that they make profits for the corporation and not, incur liabilities and, kill people and stuff like this to promote the commercial enterprise. Now, if that means that their political messages elect politicians who are very helpful to their campaign, but also, vote on completely
Yes,
other
that's-
issues like abortion or, free speech or gay marriage or all these
Yes.
other things that the shareholders don't like, well, those are incidental consequences, but the
You
corporate
mean that's
managers are doing their
collateral
job, just like when they're lobbying to promote the commercial interests of the corporation. And if the people, the shareholders don't like the incidental consequences of that, then their beef might really be with our system of government, where you elect people to vote on a whole range of issues, not just commercial for certain things and civil liberties on a different type of people and foreign relations on a different type of people.
Okay, well, thank you very much. It was a very good debate. Thank you, Mr. Shapiro, Professor Askin. Thank you, everyone, for coming. Our next event will be October 13th, Thursday at 4 o'clock with Dr. Roger Pilon from the Cato Institute.
My boss.
And on
What's the topic?
property rights as human rights.